So we're going to come back together. Clearly, people have a lot to say already. And there's a lot to hear. And we hope that the conversation tonight will be even more thought-provoking and stirring. And we want to hear from you. Tomorrow you will receive a survey in your inbox, and we really take very seriously the input and the comments and the questions that people have about the programming that we're offering this year on Race and Us. So please take 5 minutes tomorrow to fill out that survey when you see it. We'll take a short amount of time, and it will really help us learn about what's going on in this community and how we can program and engage people in the conversations that are most meaningful and important to all of us. Before I introduce our panel, I want to again say welcome, and a particular welcome to anyone who's here for the first time, to all of our guests. I know that we have folks here from State Senator Robert Jackson's office and Assemblymember Linda Rosenthal's office, and folks here from other boroughs and other communities, and even the East Side. So welcome, everyone. If you're not a member here or haven't been part of our programming, I invite you to take some materials from the back on your way out to find out other ways to be connected here. I also want to acknowledge the members of our Race and Us Steering Committee, many of whom are here tonight. If you can stand, if you are a member of the Race and Us Steering Committee. Thank you. And to thank particularly committee members Ellen Bender and Martha Acklesberg, and also our board member Lisa Zucker, who helped organize this panel and helped us identify the speakers for tonight's program. So we're going to move into the panel now. We're really thrilled that our moderator is Emily Bazelon, who is a staff writer for the New York Times and a senior research fellow at Yale Law School and co-host of the Slate podcast Political Gabfest. And Emily's going to bring her journalistic balance and expertise in the subject of criminal justice reform to shape the conversation tonight among our diverse guests. Nicole Triplett is a policy counsel in the advocacy department of the New York Civil Liberties Union, working primarily on human rights and criminal justice issues. She has years of experience in this field, including her time as press secretary and communications director of the U.S. House Judiciary Committee, where she managed messaging on a wide range of civil rights and criminal justice related issues, sentencing reform, voting rights, and immigration reform. Joe Fusito is the head of the Office of the Sheriff of New York. I know you probably didn't know that New York City had a sheriff. I didn't know that. He'll tell you all about that and the work he does overseeing the civil and criminal law enforcement services that are provided to the city and state courts and other government agencies. And Joe joined the department as deputy sheriff in 1988 when he was 18 years old. So he's been in law enforcement for a long time, serving under 5 mayoral administrations. Nigel Farina is the chief of gang prosecution at the Special Narcotics Prosecutor's Office. He's been a New York County Assistant District Attorney for over 20 years and one of the founding members of the Narcotics Gang Unit, which is responsible for the prosecution of organized violent street crime within the 5 boroughs of New York City. We are sad that 2 of our guests are not able to be here tonight. Assemblymember Dan Court was unable to attend, and Khalil Cumberbatch, who is one of the founders of New Yorkers United for Justice, which was one of the organizations leading the coalition that pushed for the passage of the legislation, is in the hospital with his wife, who just gave birth to a baby boy. So it's a good reason for him not to be here. We're sorry to miss his perspective, but we know that Nicole and Nigel and Joe will bring a lot of wisdom under Emily's guidance. Welcome, everyone. Please come up. Sorry, I'll just say one more thing. Again, we're going to do Q&A by note card, so you should have a card on your seat or on a seat near you. There are some pencils in the back. A few of us will come around about 20-25 minutes into the conversation to start collecting some of those cards. If you have a question, jot it down at any time.
Thank you. Thank you so much. Thank you all so much for coming tonight. This is a really important topic. It's also a difficult and can be a divisive one, and I'm really glad to see all of you here. No, you didn't. This isn't working. Is that better? Okay, thank you. So I'm going to start by just trying to give a little factual context for this law, both nationally and here in New York. There are more than 2 million people in jail and prison across the United States. That is 5 times the number that were incarcerated in the early 70s. If we were in Scandinavia or Europe, the level of incarceration would have remained the same as it was here in the 70s. In other words, if I had a nice chart, you would see a nice straight kind of line low across the graph for those countries, and you would see the United States have this enormous spike in incarceration, which is why a lot of us call this mass incarceration at this point in our history. We know from some calculations by a group called the Sentencing Project that while incarceration nationally is beginning to decline, if it only declines at the current pace of decline, it will take 75 years to get down to about half of our current prison population. So that, I think, if you imagine that this is too many people in prison, is why there's kind of a sense of urgency around criminal justice reform. New York, particularly New York City, is a kind of bright spot in this national story. There's a famous, or at least important criminologist at Berkeley named Franklin Zimring, and he wrote a book a few years ago about New York, and it's called The City That Became Safe. And the story in New York is that incarceration has dropped a great deal since the 1980s, much more than in the country at large, and crime has dropped even more. So in New York City, I live in New Haven, so I won't count myself, you have a crime rate that is like the 1950s, and you have an incarceration rate that is still in the 1980s. So a drop on both counts, but the crime rate has dropped even more. One of the reasons that incarceration has dropped in the last few years is that Brooklyn, and then lately Manhattan and the Bronx, started bail reform. Started basically, with some exceptions, no longer demanding that people pay cash bail to get out of jail if they've been charged with a misdemeanor, and in Brooklyn with a nonviolent felony. And so for a couple years, this started in April 2017. There wasn't a huge amount of attention to it, but the number of people from these boroughs who were going to Rikers pre-trial because they couldn't afford to pay bail dropped significantly. And this, I think, is important because when you think about bail in particular and the role that it plays in the system, bail is basically saying that the reason you're going to be in jail has to do with the amount of wealth you have, right? It's about whether you can afford to pay your way out, as opposed to a calculation based on public safety factors. Now, it is true that sometimes judges take into account whether the judge thinks you are a public safety risk when they set bail in New York, but a very unusual fact about New York that is driving a lot of the conversation around bail reform is that New York is the only state in the country that, at least on paper, in theory, in the statute, does not allow considerations of public safety or future dangerousness to be the reason that a judge sets high bail or decides to detain you. You guys are the only ones who do it that way. And there was a commitment on the part of the legislators who passed this bail reform to keep the law, to keep that part of the law. And so they did something different from every other state. There are other states like New Jersey that have ended cash bail. New York did something else. New York ended cash bail for misdemeanors and nonviolent felonies, kept it for the violent felonies, but did not give judges the discretion to hold the people who they can no longer set bail for in jail because they're worried about risk. And to me, understanding that is important for understanding a lot of the response to the law, some of the press coverage surrounding it. So I hope that's a little bit helpful just for setting some basic context. I wanted to start, if you don't mind, with Nicole, who I think is a supporter of the law, explaining why you think it's been helpful, maybe what it's meant for clients.
Sure. So I wanted just to take a step back and add something to, you know, the fact about New York in comparison to the rest of the states. So again, I'm with ACLU of New York. We've got a bunch of offices across the state, and we have legal intake lines in all of our offices, and so we're constantly hearing stories about each people's pretrial experiences and what should be the fixes. And so yes, New York, you're right. New York is the only one of the a couple of states that only allows judges to look at flight and not safety. Back in the 60s, Robert F. Kennedy, several of organizations like like ACLU and VERA said that, look, bail is supposed to ensure people back to court. This population is legally innocent, and we don't want to extend any sort of punishment beforehand. What we wanted to do with the law, which is working, is that we wanted to make sure that we uphold due process. So that very principle, this is a population that has only been accused of a crime, that has not been convicted, that has not been proven guilty of a crime, and we should treat them accordingly. Yes, maybe after they go through the adjudication process, punishment will be at the back end, but we really know, we're sensitive and we acknowledge that there are some people who are wrongfully accused, and then also we've created a process that should be baked in our system for how people should be proven guilty. And so we wanted to uphold that principle, a presumption of innocence, due process, basic access to due process. The second goal that we charted out is that, like Emily said, we're realizing that we're using jails we're investing in jails, and we're engaged in mass incarceration, mass criminalization. We're turning out people into jails and creating more threats to our safety. And so what we wanted to do is deviate from that, depart from that, and engage in decarceration. How can we, instead of investing more in incarceration, how can we bring people back home and figure out what are actually the root causes to safety, and then also shore up justice? And that's the second goal. The third goal we wanted to do is address racial disparities. At Rikers Island, jails across the state, again, where our offices are across the state, we're seeing stark racial disparities. In Rikers Island, nearly 90% of the population are Black and Latino. Black and Latinos, Latinx people together make up a little over 50% of the city population, which means that's a huge disparity. That's not to reflect who's actually committing crime. That's just reflecting who's being accused of crime. And so what we wanted to do, shore up due process, engage in decarceration, and address racial disparities. And the reason why we think the law is working is because it does all those things. We wanted to make sure that people are presumed innocent to the extent that they presumed innocent. And this is a hard principle to really articulate, to really operationalize. And so I'm not going to say that that promise is completely fulfilled, but we're closer to doing that. And that's for sure for the people who will now not have to pay bail to be able to go home. The law is also working in holding judges more accountable to their biases. So now judges, yes, they no longer have the discretion to detain people based off of if they're charged with certain charges, but now they're able to look at a menu of options of placing people in access to services while they're pending trial. So before, if someone needed mental health services, they're more likely to go to jail than be able to receive mental health services outside of jail. And so those are the three things that I know we're going to talk some more, but it helps with due process. It helps shore up more accountability for judges. Oh, and then the third thing, it reduces our reliance on money. Money has been the determinant of liberty. I work for a civil liberties organization, a civil rights organization. It's crazy to think that I am in a cage, but for the fact that I can't pay a sum of money. And so, yes, we weren't able to eliminate money bail altogether, but on balance with the other two goals, we were able to get something that we think is going to be, to get us closer to true pretrial justice and then also achieving true safety. Excuse me.
Nigel, you want to jump in?
Sure. First of all, good evening, everyone. Thank you for welcoming me to this beautiful synagogue. And I'm excited to be here with Joe, Nicole, and Emily. Emily did an outstanding job, I think, of articulating and really encapsulating the conversation that we're having today, and it's exciting. And Nicole did a good job of expounding upon it, and there's a lot of things that Nicole said that I certainly agree with. But let me preface my remarks by saying this. I'm a proponent and a supporter of criminal justice reform. I think it's long overdue. I join a lot of progressive prosecutors who believe that the days of being tough on crime are over and that we need to be smart about crime. We need to be proactive about crime. We need to prevent crime rather than thinking that we can lock ourselves up out of this problem. I think a lot of prosecutors believe that. I think that we've evolved on that issue, and I think that's great. So although I am a supporter of criminal justice reform, I'm not a supporter of this particular law in its current incarnation. To be quite honest, with all due respect to Nicole, I think we missed the mark with this law. And I think that a lot of people, we draw comparisons to other jurisdictions, and I think we're right to do that because they help inform our opinions. And a lot of people pointed to New Jersey, and I heard a lot of people say, because there's a lot of misinformation out there, that our changes mirror New Jersey's. And I know we're going to get into that later, but that's actually not true. New Jersey is allowed to take into account public safety. New Jersey affords a great deal of discretion to its judges, all right? And Emily's absolutely right. On the books, New York State, New York judges were never allowed to take into account public safety, not just because of the new law, but ever. As Nicole correctly stated, the real issue, always the only issue, was returning to court. But I've been practicing in this system for 22 years, and I can tell you with absolute certainty that every single judge that I've appeared before has taken public safety into account. They just do. I'm old enough to remember, I was a young boy, but in 1976, the Son of Sam murders, David Berkowitz. When David Berkowitz was arrested, and if he had terrorized the city for the summer, if you don't think that the judge took into account the safety and security of this city after that episode, you're crazy. Of course he did. The way they captured it, the way they frame it is to say, you're charged with a very serious crime. That serious crime is an incentive for you not to return to court, and I'm going to set bail at a high amount in order to ensure you to come back to court. But part of that calculus is always what you may do to the community if I release you. So why do we do this dance? Why are we engaged in this pretext? What we really should be doing is recognizing if we've got the right judges, if we've got judges that are bringing the appropriate amount of empathy and understanding to the situation, if we're hiring the right prosecutors. Some of you may notice that I'm a prosecutor of color. Issues of race, what Nicole and what Emily alluded to are absolutely right. If you don't think that institutional and systemic racism is laced in our system, you're being naive. Of course it is. Of course I see it myself and combat it every day by bringing more empathy. So we need more African American judges, not less. More African American and Latino police officers, not less. More African American, more women, more LGBT persons in law enforcement who can bring that understanding and empathy, come to the table, dialogue with smart people like Emily and Nicole and Joe, and come up with solutions that make sense and that work. And another point that I'm going to add about this law is the focus is on the crime. So this is a little bit of inside baseball, but just so you understand exactly what we're talking about, in order to try to get to this place of more fairness, we've decided that there are certain laws, certain crimes that are going to be bail eligible. In other words, judge could set the bail, and some that you can't. So if there's a bail eligible offense, the judge might set bail. But if there's not a bail eligible offense, the judge cannot set bail regardless of the crime. Regardless if the person is charged with robbery too. That's what we call in the DA's office rob to aided. So it's a group crime. So gangs, I'm a gang prosecutor. If gang members get together and surround an individual on the street and say, give me your iPhone, give me your wallet, they don't use a weapon, they're charged with rob to aided, judge can't set bail. Doesn't matter how many times that person has committed rob to. It doesn't matter how many times that person has not returned to court. That person could have bench warranted multiple times. Doesn't matter. Doesn't matter what his criminal history is. It doesn't matter the attendant circumstances. It's not bail eligible. In my humble opinion, with all due respect, I think a better focus would be on the individual. Afford the judge the discretion to say, in this individual case, with this individual defendant, regardless of the offense, I'm going to set reasonable amount of security to ensure that that person comes back to court. And the final thing I'll say about this is I agree with Nicole that the emphasis on money is a problematic thing. I applaud New Jersey with doing away with cash bail. I do. Because I do think it promotes too much inequities. Why is Weinstein walking out, and why was Khalif Brower in jail? These are problems that we all recognize and appreciate the inequities in the system. But the answer is appropriate judicial discretion, empowering prosecutors to make and defense attorneys to inform the court of the attendant circumstances and allow people to not engage in a false choice. We don't have to increase fairness and more appropriate results for people of color. We don't have to balance public safety on people of color's backs. We don't. But we don't have to sacrifice public safety and security in order to have more fairness. It's a false choice. Thank you.
Joe, I want to give you a chance to jump in.
So that's going to be kind of hard to follow up on, right? So we had very, very passionate discussions, but I'm going to give it my best. So I think Nicole, I think Nigel have presented very, very good points. The sheriff, by nature, tends to be middle of the road and impartial, and I do tend to feel that way. I think there are arguments on both sides, and I wanted to address some of the things that Nicole brought up. So I certainly believe that a lot of people have been incarcerated over the many years. But was it mass incarceration as one big, everybody goes to jail? No, everybody was represented by people like Nicole, prosecuted by people like Nigel. So people did have due process. But I'm not saying Nicole's wrong. I'm saying we should take a step back. What are we criminalizing? Why are so many people going to jail if we have one of the greatest due process systems in the world, where everybody has due process? They're entitled to an attorney, vigorous defense, vigorous prosecution, yet we have people, the same group of people, going to jail. Why is that? What is it unique about these laws that are causing these types of incarceration? I'm going to give you my theory. I'm not the smartest man in the world, but if we go back in time and we look, money. We look at the people who were arrested 150 years ago. We pull up the records from jail 150 years ago. Who was in jail 150 years ago? The people who have the least. The people that have the least tend to be the people in any system in the world that ends up in the criminal justice system for a variety of reasons. They steal because they have to survive, right? That's a hard concept to understand for people who may have never had to steal, or people who've always had food. So I think poverty is an important part of it. And what we criminalize is very important. We have a problem, we decide that immediately we should criminalize something. Is criminalizing the answer to every remedy? The reason I bring this up, as sheriff, I do both criminal and civil work. And I find there is greater success on the civil side. If I look at a DV case on the criminal side, and I look at a DV case in the family court.
Domestic violence, right?
Domestic violence, correct. Domestic violence, excuse me. I find that the family court's intention is actually a beautiful intention. It's to preserve the family unit, to get the services the family needs. Those are important words. So what the criminal justice system is looking to met out justice, and that's important. The family court is looking to preserve the family unit and find out what's the core of the problem. So I think we should look at what other remedies are available, because we tend to go from one extreme to another. Something's wrong, there are drugs in the country, pass the Rockefeller drug laws, that'll solve everything in New York, right? Now we have people who are in jail for decades because of drug offense, right? There has to be this thought process of maybe not criminalize everything. There has to be enforcement, and the reason I bring it up, Sheriff's Office is involved in the Kendra Law program. Kendra's Law was designed after an unfortunate young lady who was pushed in front of a subway train about almost 20 years ago. And because of it, they have a form of supervised release. It's not a criminal process, it's a civil process. And now we get into another factor that invades the criminal justice system: mental health, mental illness, right? We're looking at a lot of cases in the newspaper about all these people who were doing these things, these cases that are being brought up to our attention. I was present at 2 of the arrests for individuals who were arrested for these very, very kind of high-profile offenses, and they suffered from mental illness. And I think that's something that the system is going through a shock. Sending people to jail was a way of getting them mental health. Maybe that wasn't the best way to give them mental health treatment. And that's where I think there's a dialogue that can be open. We should be looking at mental health. We should be looking at what are we criminalizing? Is there a better way to handle these problems than making it a criminal offense?
So I think that's such an important question to ask and set of facts to bring into the conversation, because one of the for me as a reporter, one observation that I find myself seeing over and over again is that the criminal justice system in our country catches all these people that have no other safety net. It's not a safety net. Going to jail does not usually lead to good mental health treatment. But it's kind of all we've got. It's like our answer for people who are desperate for lots of reasons that are not necessarily their fault in some clear way, I would argue. So I think one of the impulses behind less incarceration is trying to make sure that there are other services. And one thing Nicole mentioned is that while it's true that judges can't put people in jail for this set of offenses, there are other services they can offer. And a few of the stories that kind of got a lot of attention in the tabloids were stories in which judges could have ordered counseling or other kinds of supervision to people, particularly the woman who was slapping Orthodox Jews in Brooklyn. She did not receive mental health services the first time that happened, and that could have contributed to her doing it again. So it isn't, these aren't the only choices. I just wanted to throw that out there. Nicole, do you want to talk a little bit about some of the questions Nigel brought up?
Yes.
Uh-oh.
No, I think this is, Nigel, you said something before we started, that these are conversations that we weren't really engaged in as a city, as a state, and actually nationally before talking about bail reform. So we're talking about what keeps us safe, how do we undo a history of harms that our criminal legal system has brought to so many communities across the state.
That's right.
So it is a complicated conversation, which I appreciate. One, I want to respond to your reference to New Jersey and allowing judges to be able to look at public safety. I think that notion of like public safety is something that many of us who have pushed for bail reform appreciate, because all of us want to be safe. This is not a mutually exclusive type of desire. And just because you're saying that certain people should be presumed innocent and have the access to go home is not saying that you don't want to be safe. That's a fundamental feeling. The issue and the concern that we have with a model like New Jersey or any other model that would allow judges to be able to look at public safety is that they're not looking at public safety in an accurate way. What we've seen is that they're trying to predict whether or not someone can commit a crime by looking at the same factors that we believe have a lot of racial biases baked into them. So New Jersey uses this. Judges don't just decide on their own who is going to commit crime. They look at this risk assessment tool, which is like an algorithmic tool. It's a formula, if you will, that turns inputs out into outputs. It's usually data that includes bunch of case outcomes, convictions, arrest history, other touches to the court, the system. What the problem is that it repackages. So I've heard people say that, okay, this is an objective tool. It'll help judges. We know that there's a well-documented issue of judicial racial biases, implicit biases, whatever you want to say, and then also laws that have racial biases baked within them. So we know that's in the system. How do we depart from that? And people have been resorting to these tools. Those tools only repackage the same decisions that have the biases in them and then say, okay, now the responsibility is not on the judge to have to justify why they want to lock someone up. Now they get to use this as a justification, and we're just perpetuating the same system that we're trying to depart from. And so what we're concerned with, and I'm going to recap, that yes, if there was a way to accurately determine whether or not someone would commit crime, we would do that. At the pretrial stage, what we're learning and what we've seen is that when you give a judge the ability to be able to say, look, Nicole, you've been accused of this. I'm going to end this 90-second hearing. I'm going to say you should be locked up because I feel like based on your record, you will commit again. That type of decision has so much discretion that more than likely it will lead to widening racial disparities, because we've seen that in every point of the criminal legal system. This is not about safety. This is about trying to predict, based off of your own assumptions, whether or not someone will commit crimes. And so what our concern is that we're not going to move away from any sort of mass incarceration crisis. What we're going to do is perpetuate it in a way that black and brown people will bear the brunt of what was done in their name as in terms of reform, but it will actually be a bigger beast. And so just to think about this, if you take away money, we would not be satisfied if you take away money and then in its place provide mass detention. And that is the fear. That's not a fear in New York. That's been a fear in California, where they were
California, different law.
different law.
Not in effect, I don't think.
Not in effect yet, but a different law. New Jersey, we're fearful of the swap of detention versus money. The problem is we're wanting to get to what exactly are we criminalizing? Are we criminalizing race? Are we criminalizing poverty? Are we criminalizing other issues that have nothing to do with threatening our safety? And until we're able to peel back the layers, I'm afraid that we're just going to keep doing this whack-a-mole where we remove one social evil to just replace it with another.
I just want to quickly say about New Jersey that since New Jersey implemented its law, the jail population is down by more than 40%.
And racial disparities have stayed the same or have gone up in certain parts of the state.
Yeah. So the racial disparity that you were talking about earlier, we see almost everyone who's in jail pretrial is young black and brown men. That is still the case in New Jersey, but there are fewer of them. So that's sort of what the state of their law now that it's been implemented.
And in other states, the pretrial detention has gone down, and then over time has gone up. And so New Jersey law has only been in effect since 2017. Again, this is a complicated overhaul. To be able to make an assessment, you would have to be able to let it take time for us to know how effective it is.
Nigel, do you want to say something more?
Sure. So and I appreciate both of your comments. What I'm hearing from everybody here and in these conversations that I've been having is we want to inject more fairness in the system. We recognize that there's been disparities, to Joe's point. We understand that we want our system to be reflective of how we as society want to understand a criminal justice system should be in the ideal form. It should be about fairness. It should be about justice. But as a subtext that I'm hearing from all of these comments is, what I'm listening and I'm hearing is balance, right? So we want to understand, to Nicole's point, that, okay, we appreciate that there's been racial inequities and racism in the system. What do we do about it? Well, what New York has decided to do is they said, okay, we're going to decide certain offenses the judges can't do pretrial detention. We just think that that's just not a good solution. In the interest of doing two things, right? Trying to get better, more favorable, more just results for black and brown people, but also to do away with something that all of us seem to have a problem with, which is this antiquated notion that cash is a good guarantee for whether or not people come back to court equally across the board, whether you're a millionaire or whether you have, very little means at your disposal, that guarantee should be the same. And it doesn't seem to sit right with all of us. But now we need to come up with the tough job of finding a solution, a substitute for this system. And we have to strike a balance. I don't understand why, if we, as a society, elect and appoint accomplished people in our profession, judges, who make decisions about people's lives every day, can't be imbued with the same responsibility to be able to say, I'm going to take into account and weigh this person's criminal history, the fact that they've bench warranted and did not return to court 3 or 4 times, the fact that they have committed, allegedly, this very serious offense, but because the charge is manslaughter, taking somebody's life, is not a bail-eligible offense. So the judge is now divested of the authority to set bail. or rob two, or grand larceny. So Bernie Madoff, if he was charged in New York State, the judge would be powerless to set bail, regardless of the harm. I don't understand why the offense should dictate that. I think the individual should dictate that. And I think the judge, receiving information from the prosecutor, from the defense attorney, can make decisions. And if we don't think the judges are proper arbiters of that, then they shouldn't be judges. And if prosecutors aren't responsible actors in their roles to enforce
Oops. Here.
that was the forces of the universe saying, Nigel, be quiet. No, listen, I appreciate this conversation. I appreciate every remark that's been said. I appreciate your attention. This is such an important conversation. We need to understand that I believe as a prosecutor in restorative justice. I'm a gang prosecutor, person of color. Majority of cases that I prosecute are young African-American men and Latino men between the ages of sometimes as young as 12 and 21. That is what I do every day. This is difficult for me because when I was 16, I was stopped, almost arrested by police. I've been treated unfairly by law enforcement in my own life. I wasn't born in this suit, right? I'm a person of color. So I bring these experiences with me, and I understand that African American and Latino communities, they don't hate law enforcement. They don't reject law enforcement. They want better law enforcement. They demand it, and they should. Brownsville, Brooklyn should be just as safe as the Upper West Side. It should be. And why isn't it? And there's a lot of reasons that go into contributing to that, but we as a society can do better. And in trying to embrace the laudable goal of doing away with cash bail, which really does criminalize poverty, and by trying to embrace the notion that we want to have restorative justice, so when we arrest young people that are going to eventually come back into the system after they come out of jail, if they go to jail, that they could be reintegrated into society, get job training. Why should prisons be, the disreputable, unsanitary, awful conditions that we should be educating prisoners. We should be exposing prisoners to opportunities. We should be doing job training. Prison should not be a place where we make better criminals. Absolutely. And prosecutors would be happy to join this conversation with defense attorneys, with well-intentioned people in ACLU and with sheriffs to make this end result that result, because Nicole is absolutely right. We all want to be safe. We all want to have a better community, right? But we have to strike a balance in getting there.
Take my mic back. Let's do some questions. Yep, no problem. Oh. Is that what you were trying to do? No, something else.
So we're glad to add your voice to the conversation, and maybe we'll
Okay.
say a few words
Hi.
before we go to questions.
I don't know how much of you that you heard, but I wonder if you want to speak as from your role to this issue. I don't. What? Sorry. My mic's not working again. Okay. Did they all stop? Oh, talk into the mic. Okay. Welcome. Would you mind jumping in? I'm not quite sure how to bring you into the conversation. We've talked a lot about the actual specifics of the law in New York and somewhat about how it compares to New Jersey, and I've heard different points of view about whether it works the way it is or needs some changing.
Well, my apologies to the audience. Thank you to my fellow panelists for being late. I was at a separate forum on this issue with the public advocate, Jamani Williams. It's good to be back in this synagogue. It's been about 30 some odd years since the last bar mitzvah I was here when I went to Manhattan Day School, but thank you. I heard some of the prior discussion. I'm a state legislator on the Upper East Side of Manhattan and Midtown for 8 years. I'm also a practicing civil and criminal defense attorney. I do public defense work. The 18B panel, I represent people in Manhattan Criminal Court who can't afford lawyers. So I come from the perspective of both as a legislator who was part of the efforts to reform our criminal justice system last April, as well as someone who's actually represented poor people in Manhattan Criminal Court for the last 3 years when I'm not in Albany. I wrote my own legislation 4 years ago ending cash bail because, as my colleague pointed out, from my vantage point, the connection between one's liberty and one's wealth, or typically their lack thereof, is immoral, if not unconstitutional. Different courts in different states have said that very same thing, only one or two in New York State. The legislation we passed in April did not end cash bail. It limited it, mostly to misdemeanors and a couple of felonies involving burglary or other acts which nobody would agree are good acts, but none of the acts which engage physical harm to another person. I missed a lot of the discussion, so I won't reiterate. I'll wait for the next question. What I will say, to my colleague's point, there is efforts to roll back some of the legislation, to tweak it, to amend it. I reject those proposals, either adding a proposal that would include the concept or idea of dangerousness. To me, to add that, it would not be worth doing any sort of legislation. I'd rather go back to the old bail system than add that single word, which is tantamount to people of color, or most of the time being black and being a man. That's been shown by data and over time in many jurisdictions that have used that word. Respectfully disagree with my colleague on the point of judicial discretion. It is my view that judicial discretion is part of the reason why we're in this mess to begin with. The existing bail statute that we reformed that was in place for 53 years, allowed for essentially unfettered judicial discretion. And I'm not suggesting any individual prosecutor, but this salad, if you will, of overcharging by district attorneys, judicial discretion has led to a disproportionately high number of people in our pretrial locations. In fairness, in New Jersey and under the mayor, the numbers have gone down, but the racially disproportionate effect remains, and still our numbers are too high for a presumed innocent population. So I don't think adding judicial discretion based upon the 53 years of how this bail law was interpreted by judges is going to get us a different result. I've gone on long enough on how I see things, but I'll wait for the next question. But I appreciate the opportunity to be here, talk about the legislation that we in Albany fought for in April, and the next 5 weeks will be critical, not just to what type of bail reform or bail system we have, but what type of criminal justice system we have in the state of New York.
Should we take some questions? Great.
Something you just said about the law not wanting to roll anything back in terms of the law. And so there are a couple of questions here about that idea of a middle ground. Is there, one question, how does passing a law like this become an all or nothing issue? What middle ground is even possible? What middle ground would work? So you don't want to add the word dangerousness to the law, but is there a middle ground that you feel might be a better fit? Because people seem to be concerned with this being an all or nothing question.
It's hard to say that it's an all or nothing situation as it is right now, because we do have a partial money bail framework, and then we also, the judges still maintain discretion to pick what's needed in each case to return someone back to court. It's just not the discretion to be able to detain on certain cases. The interesting thing about Albany is that when you do pursue legislation and it goes into effect, it really does take time to figure out if it's working. And 7 weeks is just too premature. Like that's not sound advocacy, in my opinion. It doesn't reflect a sound response to the calls of many communities that called for this law to go into effect. And so I think right now what we need is like more data. Right now, if we were to change the law, it would be based on what we're seeing in the news outlets, and I don't think that's a fair representation of what's happening. And then the third thing is, this law is going through the budget, and so I feel like we're already we're on a slippery slope, because you're seeing the politics of the state play out, and you're seeing the fear mongering, you're seeing people who are invested in maintaining the old system. They're trying to figure out how we can get to a system where we can actually detain more people. And so it's hard to be able to engage in that type of way when you know that there are interests out there that they are not acknowledging that there is a problem that we need to solve. They are saying that we've got to figure, and this is not Nigel, this is what we discussed before we got on the stage, but there are people who are invested in trying to figure out how we can detain more black and brown people. And that's just, it's not a middle, there's no middle ground in engaging in that type of argument.
Again, another hard follow-up from everyone. I think the Assemblyman brought up a very good point, and I wanted to mention it if the time came forward. And I think Nicole has brought up that this legislation just passed and we don't have enough data to make an accurate determination. And I agree, it is relatively new. I respect Nigel's position because he's a prosecutor. But in my role as sheriff, I have to look at laws, and I have to look at very old laws, and I do a lot of research concerning the laws in New York State. And one of the things which the Assemblyman touched on is our laws are very old. We don't realize how old they are. I'm just going to give an example. There's a very particular section of the CPL law that talks about a 10-day period, and it has a little footnote in all the commentaries. That 10-day period was how long it took to get from anywhere in England to the court in Westminster. And then the colonists brought it over, and it became part of the fabric of our thought process. Just as Nicole said, many things are enrolled into the fabric of our thinking. And we don't even know why we're doing it because the book says it. Now, in 1961, Governor Nelson Rockefeller said that the Code of Criminal Procedure in New York State was archaic, and it needed to change. And for 10 years, a temporary commission, the Bartlett Commission, examined each piece of the penal law and the Code of Criminal Procedure, and they created the modern-day penal law that we have now and the modern-day criminal procedure law. That was great. That's a modern-day procedure in 1971. 1971, we had the Rockefeller drug laws. We had a different type of environment. And I think Nicole is right. We don't want to play whack-a-mole. We don't like this, jam on the brakes. We want this, go forward. It makes everybody seasick. I think what's important is a long-term examination of the entire criminal justice system, much like Rockefeller did from 61 to 71. Looking at each piece and how much does it play in the overall fabric of why people are being incarcerated at the level they are. Why does the court system do these things? It's not going to be solved overnight. No real good problem is ever solved overnight. You need long-term study, and you need committed people. You need people like Nicole. You need people like Nigel. You need the Assemblyman. You don't need me, right? But that's the type of thing that I think we need to advocate. We're trying to solve a problem that was 30 years in the making. Now it's changed, and now everybody's kind of upset over it. I think we need to have a long-term solution, and it's the examination of the entire criminal procedure law in New York State.
Should we take another question?
I'm not going to take that.
Great, you're here just in time.
Right, this is why we need you.
So, the reason why a significant piece of criminal justice reform, I should say plural because we changed the discovery laws and speedy trial laws, was determined in the budget rather than through a piece of legislation, which would be the preferred model, is deep constitutional flaws in our state government. And they go back to the early 2000s in a series of Court of Appeals cases, Pataki versus Silver. And without getting too boring about the cases, they stood, unfortunately, for the proposition that the governor has extraordinary powers within the budget process. And that decision, and it's not Andrew Cuomo's fault, because if it was a different governor, he or she would use those powers in the same way, that any controversial piece of legislation, any piece of legislation that might not actually have full support or might have support, but it's not worth doing in the eyes open in the public and is done through the budget. So unfortunately, the new normal in Albany, because of this deeply flawed constitutional process supported by the Court of Appeals in 2 cases, is every significant or nearly every significant tangible issue, whether changing the criminal justice system or virtually anything else, is done through the budget, which must be due by state constitution on April 1st. So that is the flawed systemic reason why criminal justice reform was done in the budget as opposed to where it should have been done in a up or down vote with full public hearings, with the full vetting of the public, without a message of necessity that would require us to vote in 72 hours. The process led to what I still think is a good piece of legislation, but that is the answer to the question why, unfortunately, significant criminal justice issues that affect 20 million New Yorkers are done in the context of a document, the budget, that should be all about money and finances and not about reform of our criminal justice system.
Truly, do you want to bring another question in?
No? No?
Here. Wait, let's see. Yeah.
We're running out of mic. Hello?
Yeah.
Oh, there we go. Okay. Yeah, yeah. So, you know, this is an interesting thing. We talk about anecdotal data as if it's problematic. We hear things like, oh, we don't want to engage in fear-mongering, and certainly we don't. We don't want to engage in hyperbolic discussions. But is it fear-mongering to point out examples that actually happened, not hypotheticals of what could happen? I mean, the anti-Semitic assaults, I was in court when that defendant was released for a substantial A1 drug offense, trafficking kilos of cocaine, and said, I can't believe that they let me out, and I'm not coming back to court. I mean, I was there when that happened. This is real. So to say it's fear-mongering is an oversimplification. I understand also that it's relatively new in this process. But it's not been just 7 weeks, with all due respect. Judges began implementing this law on November 1st. Some judges. Nicole corrected me and said some judges. The judges, I can only speak about the judges that I practice in front of. And they started implementing this law in November. And rightfully so, because you can't transition a system on New Year's Eve. So you have to begin transitioning the system. So we do have a substantial amount of data that indicates that certain crime statistics are ticking up. And then other people will critique that by saying, well, hold on a second. We don't necessarily ascribe or know that those people who are increasing the crime are results of people that got out of jail and are. That calculus is very difficult, given the fact that a lot of those crimes aren't even solved yet. So we don't even know who perpetrated those offenses, the shootings, the grand larcenies that are up, and the robberies that are ticking up. But what we do know is that for years, long before this criminal justice reform was implemented, well-intentioned, progressive prosecutors like Darcel Clark, Eric Gonzalez, Cy Vance, people in my office, Bridget Brennan, have been implementing reforms to drive down statistics. Mass incarceration in New York City, and I understand to take Emily's point about New York State, upstate, and that's a separate issue. But since 1991 to 2009, incarceration rates has dropped 40% in Manhattan. This is significant. And that's because we've been smarter about the way we're crime. We've been embracing restorative justice. My office was one of the first to implement alternative to incarceration DTAP program for drug offenders whose crimes were motivated by their addiction and not by pecuniary gain. We've been doing this for years and years, and we can be trusted to do this. And if we can't, then you should kick us out and get better prosecutors who can, and better judges who can. So I think that there is enough empirical data to say The only significant change that we've seen in the past 6 months, year, 2 years, has been this law. And crime is now going in the opposite direction than it was before. I think that's significant and worth noting.
Just want to respond. No. But okay, I couldn't wait. So two things. I think one, you're right. Certain judges were like rolling this out before, but there is no way we can know that because the law didn't kick into effect January 1st. So it goes back to the whole piecemeal data and trying to draw a correlation based off of what we may know or what we may not know. We don't know what motivated a judge to release someone if they weren't compelled by law to release someone before the law went into effect, if that makes sense. So you can't, I could never put that into data. But what I can say is that and I wanted to clarify something you said too, Emily, like if these DAs were engaging in the type of bail reform that was meaningful and purposeful and would achieve the goals that we've already set out, we wouldn't have had a Khalif Browder. Khalif Browder happened not to the story of Khalif Browder, many of you have heard. He initially was in jail for a $3,000 bail on a Rob 2 because he was accused of stealing a backpack. That's stealing a backpack with a person next to you is a violent felony offense in New York. That was what he was accused of. The bail was set, and then he ended up spending, he couldn't initially afford the bail, and then he was kept in jail for other reasons, and then he was in for 3 years and was subjected to a whole host of horrors, including solitary confinement. So this notion that maybe, yes, we'll hear a news announcement from Manhattan DA Cy Vance that says that he's going to now start not imposing bail on certain offenses is not something that he was compelled by law, and we've seen in court that he was not actually doing consistently. And so that's actually the reason why we needed it. This was not just for an upstate. I want to be clear. This law was not intended just to resolve an upstate issue. We had a fair share of problems, even by DAs who, like Darcel Clark, like Cy Vance, like others, who said, yeah, I'm progressive. I see that bail should not be used. That was a disconnect with what was happening in reality, which is why we're in the situation that we're in. And then I think the third thing is that, yes, the data we should be informed by what people are experiencing, especially folks who have proximity to the issue. We're hearing from family members that now instead of my son just being shipped off to Rikers, now I can have my son get services that he would otherwise not have been able to get, and then go back to court. People are going back to court. And so we have a month's worth of data for that, but again, that's just too small of a sample for us to be able to say, okay, this is why, these are all the things that we should keep in place. We just need to make sure we keep this law in place so that we can see a host of factors and how people are being impacted.
I'm just going to jump in because this is something I've done a lot of interviews about. The notion that you could take 6 weeks or a couple of months of data and draw a conclusion, that's just like criminologists laugh at that notion. It just takes much longer to know what crime trends mean. They go up and down in short-term periods often. You could look at other periods in New York and you could see a spike in robberies, which is one of the things the chief of the NYPD pointed to in his extremely selective depiction of crime going up in New York. So while I'm all for data, I mean, it's like what I do as a journalist is try to look for stories that represent the data as opposed to misconstruing it or misrepresenting it. It's just too soon. You guys, if that's how you want to make this decision and it's a good thing to think about, you have to wait and see how the law plays out. The other thing I just am noticing in the way we're talking about these issues, part of the question in how we think about this is like, whose stories move you? Are you more concerned about the person who, hit Jewish women in Brooklyn and got out? Because that's scary, or are you thinking about someone like Khalif Browder? It is really hard to do criminal justice reform in this country because usually people like you, like me, people who vote, think more in terms of wanting to distance themselves from anyone they think might commit a crime. And that's why we have so many people in jail and prison. So if those are the people whose faces and thoughts are in our heads while we decide what to support the legislature, whether we think your assemblyman here is correct and you're going to trust him or not, like you'll end up again with kind of this entrenched interests that are always pushing against reform, because it's always easier to, if you're looking at things through the prism of fear, to lock people up than to let them out. Sorry.
Is this better? Okay. Could I?
Thank you.
If I could just make two quick points on data points. Look, the idea of the quote-unquote progressive prosecutor is a little overstated. We should really be talking in the concept of the decarceral prosecutor and who's actually releasing those from a presumed innocent population who should be able to go home and work out their defense within the comforts of their home and keep their job. We're in Manhattan, so, Mr. Vance was brought up. Understand this, it's not me. In the Chief Judge, Judge Lippman's report on closing Rikers Island, he singled out the Manhattan District Attorney's Office is sending a disproportionate amount of those to Rikers Island. So we should be honest about what the facts are. That's not me saying it about Mr. Vance. That's former Chief Judge Jonathan Lippman in his report. Secondly, the trigger points on data that to me are relevant are not crime statistics with a nebulous connection to a law that's 7 weeks old. I think you would, if you were honest about what you're looking at, you would say, let's look at the rearrest numbers for those who are out on bail, and let's look at the bench warrant numbers for those out on bail who don't return to court. Unfortunately, outside of New York City, in the 57 counties outside of New York City, we have nearly no data as to those points. And it'll be for a different discussion to say there are multiple pieces of legislation that have been languishing, unfortunately, in the legislature that would have provided to you that information. We do have some of those numbers in New York City for the 5 boroughs, and I will just point out, in all of the police commissioners opining and missives about everything that is wrong with the current law, he has never, ever cited to any of those numbers to suggest we have a problem with the current bail law. So I leave you to draw your own conclusions regarding those absence of facts.
Another question?
So this is something that we haven't really touched on yet this evening. Seen concerns emerge, I think concerns about the legislation emerge from the Orthodox Jewish community. What are those concerns? What is your response to them? And then I would add kind of more broadly, what has been various Jewish responses to the law and to this controversy, and what should be the Jewish community's involvement in your perspective?
I think this should probably be the last question. Does anyone up here want to take that question?
As a Jewish legislator, I guess it does fall upon me. And with your assembly member here, Linda Rosenthal, and another Jewish legislator, Harvey Epstein from the Lower East Side, we wrote an op-ed 4 weeks ago, at least setting forth our position that conflating support for bail reform with being anti-Jewish or not Jewish enough was wrong, and to me offensive as a born and raised Jewish person, and that the idea that somehow being for supporting bail reform, which, let's be blunt, is about releasing black and brown men, somehow makes you anti-Jewish. I was offended by that notion, and I wrote an op-ed in the Daily News with 2 of my colleagues pointing out the absurdity of conflating those two things, which ought never to be conflated. It is a difficult thing when you see other Jewish people attacked by mentally ill people, but I think it's important to focus on these hate crimes were invariably by mentally ill people. And the idea that we can criminalize or incarcerate our way out of our problems with mental illness through incarceration has been an abject failure for the city of New York. 40+% of those in Rikers Island, and I suspect the numbers are the same for those in the prison barge and the tombs or anywhere else, are suffering from mental illnesses, from severe to moderate. And I think we all understand that any prolonged stay in our county jail facilities will exacerbate that mental illness. So we're dealing with, unfortunately, we deal as a society and a government in the wrong way with the wrong societal problems. Drug addiction, mental illness, homelessness, have for so long been dealt with in our county jail, correctional facility, and our courtrooms. And for once, at least with this legislation, we're changing that calculation and saying we as a government, and that includes me as a state legislator, we have to deal with mental illness outside of our county correctional facilities. But to the question of Judaism and individual legislators, and somehow I reject that notion, was offended by it, and spoke out publicly against it.
I think we should probably end there, if that's all right. Does that seem like a good place to stop? All right. Thank you all so much. Thanks for this great panel. Thank you all so much for coming.
I want to thank the panel once again for sharing your voices. I just want to raise up some of the work that we're trying to do to hold all these stories. There's a reason why we're having a panel like this, as Shuli indicated in the beginning. And if you remember, about a year and a half ago, we had Brian Stevenson on this podium. And he brought up 5 things about what would redemption look like in this country. 1, proximity. 2, changing narratives. 3, being uncomfortable. 4, having hope. And 5, that we're here to serve. And so what I want to raise up in the question of proximity is most of us are more proximate to one of the people on the stage or to their stories, or we have lack of proximity, as Emily said, to many people who are deeply impacted by laws. And so one of the questions I think we're trying to explore as a community is, do we know the whole story? And are we proximate to the issues? And if we're not, how might we get a little closer? Whether that's to people who have been impacted by this law, people who are standing in court and prosecuting these laws, some of whom are in our community, and people who have gotten out or have family members who are in court, or people who are building those laws under duress with the budget. That's one question.
Everything in Albany is under duress.
Right. We're under duress because Albany is under duress. The second question about changing narratives is, as was brought up, what does dangerous mean to us? What is public safety? How do we define that? Because what it looks like may carry out heavy assumptions about our own narrative and why we as BJ are doing this work on race and us. It doesn't mean that we all, and I think your point is well taken, we all care about all your points. We all care about public safety. But I think if we explore our own narratives, we'll realize we may have to redefine what safety looks like. Because for certain populations, policing doesn't look like safety. Or for certain populations, when you think of the word dangerous, a black or brown man is the one who shows up in our picture or on our TV screen. So the question is, what narratives are we carrying as a spiritual and religious community that help us align more clearly with one of the people on the stage or not, or being willing to listen to one of the people on the stage or not? 3, I think when we get in a room with people who share different opinions, it's agitating. Those opinions exist in our own community as much as they exist on this stage, and we as a community have committed to living with the agitation and not rushing to just jump on the bandwagon that we're used to jumping on, which is hard. I'll say, as a rabbi of this community and someone who cares deeply about these issues, it's hard to pause and say, what don't I know? And be agitated with what don't we know, and then move from there in order to then move on to the position that we actually feel aligned with, right? In our tradition, there's a principle, Elu ve'elu divrei Elohim chayim, these and these are the words of the living God. There are different positions that have merit, but there is a point which often people don't quote from that passage. These and these are the words of the living God, but the law is according to Hillel. At some point, we have to decide. And as much as we listen, we also have to act, which is the fourth position, which is hope. If we don't think things can change, then we will not be redeemed. And so I think whatever movement we have to make, because we know that the status quo is not good enough, that it's not fair, it disproportionately affects people of color and people who don't have money. And that was in agreement on this stage. So if we know that's to be true, something needs to be done. And many people on the stage are working to make that happen in different ways, as journalists, as lawyers, as advocates, as assembly people. And 5, I think the question as a Jewish community and as this particular community is, what's our role? Since none of us, I mean, some of us in this room have served in some of these roles. How do we participate? And I think of those 5 qualities that Brian Stevenson raised up, we're all, I think, behooved to try to think, what is my part in all 5? To dismantle what I'm carrying, to get proximate, to think about how in my discomfort I might learn something new, to not give up, and to say, what's my purpose? And I promise you, as a community, both collectively, we're trying to do that internally with our discussions, through our Race and Us work with the steering committee and all the things that are happening, both, by the way, as a community writ large, as well as in our staff, and also with our partnership with SPSA, the Church of St. Paul and St. Andrew, through our racial justice work. So I hope and pray that this is an example this evening of trying to dive deeper in an issue to gain more understanding. I hope none of us are leaving without some kind of agitation to think how we can move forward and do the work that we need to do. And we will let you know as we see things move forward how we will collectively or individually participate in this as a community. I really want to thank the panelists once again, and to all of us for coming out, and also to share, when this goes out live stream, to share it with people in the community, so more and more people. The worst thing is if people don't know what's going on or misinformation is out there, and there's plenty. And lastly, I just want to name that as a Jewish community, it really is incumbent upon us to understand how our power moves. That we're disproportionately listened to, and when pain hurts our community, it rises up very quickly because of how our power moves, no matter what color skin we have as a Jewish community, which is diverse. And I think we just need to take that into account as we think about these issues and how the Jewish community has participated in them in many ways. You know, on all sides, by the way. There are very Jewish progressives, the progressive Jews who are fighting really hard in certain ways, and also other parts of the Jewish community that are fighting against. And how do we want to be a part of that conversation internally as a Jewish community as well as externally, and to not rob ourselves of being caricatured as a community in one way or another, but to really think about the complexity of our own community and how we might want to discuss it together. So thank you once again, and thank you all for being here. Good night.